I had the pen in my hand. I had already written the sentence down, every line of it, the fine, the suspension, the community hours, and the last part, the part that made the hospital's legal team go very still when I read it aloud. I had decided all of it before I walked into that courtroom that morning. But I kept looking at the man sitting across from me, and I kept thinking about a woman named Margaret Osei, and about what the 48 hours between Thursday evening and Saturday morning had cost her. Then I said it out loud and the room changed. Let me tell you how we got to that moment. Before I go any further, subscribe to this channel. I do not say that as a formality. I say it because there is one piece of evidence in this case, something that took 3 days to surface, something that almost did not make it into the record at all, that turned this case from a civil dispute into something the medical board had no framework for. I want to make sure you are here when I get to it. Subscribe now, then let me continue. I have been on the bench for 22 years. Before that, I practiced civil law for 9 years, mostly in healthcare liability. So when this case came across my desk, I recognized the shape of it before I had finished reading the first page. I have seen versions of it before. Hospitals pressed for beds, administrators making calls that physicians are not comfortable making, patients discharged before anyone is truly satisfied that they are ready to leave. I have seen it. I have ruled on versions of it. But I had not seen this version, not exactly this one. The case was filed in the spring in the Civil Division of the Superior Court. Margaret Osei, 63 years old, versus Northgate Private Medical Center and its chief administrative officer, a man named Derek Callum. The filing alleged premature discharge, negligent administration of care, and, this was the part that stood out to me when I first read it, deliberate documentation alteration in the patient record. That last part is not a standard inclusion in a civil filing. It means someone did something to paperwork, and in a case involving a stroke, paperwork is not a small thing. Margaret came into my courtroom on the second day of proceedings. She walked with a cane, her right side still moving differently than her left, the kind of asymmetry that does not announce itself dramatically but that you notice if you are paying attention. She sat down slowly. She set the cane against the table with a particular carefulness, like she had practiced the motion and she did not want to drop it. She was wearing a navy dress and small gold earrings. She did not look at the defendant when she sat down, not once, not because she was avoiding him. I do not think it was that. I think she had already said everything she needed to say to him in her mind, and there was nothing left in that direction that she needed from the room. When she testified, she spoke slowly, not because she was unsure, because her speech processing had been affected by the stroke, and she had worked with a therapist for 11 months to get to the pace she was at. She said that herself on the stand. She said, "I used to talk faster than my brain could keep up. Now they match." That was the line I wrote down. That was the one I kept. Derek Callum was in his late 40s. He wore a charcoal suit every day of the trial. Different shirts, same suit. He had the kind of posture that comes from years of being the most senior person in every room. Shoulders back, chin slightly lifted, hands either folded on the table or resting flat on the armrests of his chair. He never fidgeted, but I noticed what he did with his eyes. When testimony was going against him, he did not look at his attorneys. He looked at the table in front of him, at a fixed point, and his jaw tightened almost imperceptibly. When testimony was going in his direction, he looked at me. Directly, the way someone looks at you when they believe the outcome is already settled. He had been the chief administrative officer at Northgate for 7 years. Before that, he had held similar roles at 2 other private facilities in the state. His attorneys were good. They had prepared him carefully. He answered every question in complete sentences. He used the word protocol 14 times during his testimony. I counted. I want to stop here for a moment, because what I am about to tell you is the part of this case I had to sit with the longest before I felt ready to speak about it publicly. Subscribe before we go further, then take a breath, because this next part matters. Margaret Osei was admitted to Northgate Private Medical Center on a Thursday evening, October 14th, at 7:22 p.m. She had been at a church function when she told the woman sitting next to her that her left arm felt strange. That woman, a retired nurse named Gloria Akeampong, recognized what was happening immediately. She did not wait for Margaret to finish the sentence. She called 911 while Margaret was still speaking. Margaret arrived at Northgate's emergency department and was assessed within the hour. The imaging confirmed an ischemic stroke. The attending physician, Dr. Priya Nair, documented that Margaret required a minimum 72-hour observation window for neurological monitoring and anticoagulation management. That notation is in the clinical record. It is dated and time-stamped. Dr. Nair was not ambiguous about it. She was specific. 48 hours later, on Saturday morning, October 16th, at approximately 9:40 a.m., Margaret was discharged. Not by Dr. Nair. Dr. Nair was not consulted. She was not called. According to her testimony, she learned about the discharge when she came in for her afternoon shift and checked the system. She said, "I saw the record and I stood at the nurse's station for about 30 seconds trying to understand what I was reading. I wrote that down too. The discharge was authorized by Derek Callum. His authorization is in the administrative record, time-stamped 9:17 a.m. on Saturday the 16th. His justification, as entered in the system, was a single line. Bed reallocation, census pressure, patient stable for outpatient management." That is a direct quote from the administrative log. I saw it on the evidence table. It was printed on plain white paper, 3 paragraphs long, and that one line was at the bottom. What happened next is the reason we were all in that courtroom. Margaret went home. She did not have adequate anticoagulation medication because the pharmacy order had not been finalized before the discharge. She had no formal discharge instructions from Dr. Nair because Dr. Nair had not authorized the discharge. She had no follow-up appointment scheduled because no one had called ahead to a neurologist. She went home with a partial medication list, a general pamphlet, and a signature from an administrative office on a form that should have been signed by her attending physician. 31 hours after she got home, Margaret had a second stroke event, a transient ischemic attack, a warning stroke that her neurologist testified was, in his medical opinion, significantly more likely to occur without the anticoagulation therapy that should have been in place. She did not lose consciousness this time, but she lost additional function in her right hand. She had been a seamstress for 31 years. After that second event, she could not reliably thread a needle. If you are the kind of person who stayed with this story this far, not because it is dramatic, but because you actually want to know what happened, then you already understand why I am telling it. Subscribe. This is what I do now. I tell the stories that need to be told. The first wave of evidence established the facts I just described: the timeline, the documentation, the discharge authorization log, Dr. Nair's testimony, the medication gap, the second event. This part took 2 full days. It was methodical and careful, and by the end of it I had a very clear picture of what had happened on a mechanical level. The second wave is where things became more complicated. Callum's defense raised something that I want to be honest about. It was not unreasonable on its face. Northgate had been operating at 94% bed capacity for 6 consecutive weeks. There were patients in the emergency department waiting for inpatient beds. There were documented cases of delayed admission leading to worsened outcomes in other patients. The defense argued that Callum had made a triage-level administrative decision under real pressure, that his documentation of Margaret as stable was drawn from nursing notes taken at 7 a.m. that Saturday morning, and that his decision fell within the scope of his administrative authority under the facility's internal governance structure. I heard all of that. I considered it. I want to be clear about that because it is true. But then came the third wave. On the third day of testimony, one of the plaintiff's attorneys called a witness who had not been listed in the original disclosure. This required a short procedural hearing. Here is something most people outside the legal process do not know. In civil proceedings, a late witness can be admitted if the party can demonstrate that the information was not reasonably discoverable earlier and that the opposing party will have adequate time to respond. The judge has discretion on that. I exercised mine. I allowed the testimony. I will explain why in a moment. The witness was a former Northgate billing coordinator named Anisha Reddy. She had left the hospital 8 weeks before trial. She came to the courthouse with a personal copy of an internal email chain, printed 6 pages, dated from the week before Margaret's admission. The email chain was between Callum and the hospital's revenue management team. In those emails, Callum referenced 3 specific patient cases. Margaret was one of them, though she was referred to by patient ID number, and he discussed projected bed day costs and reimbursement timelines. There was a line in his email, sent on October 11th, 3 days before Margaret was admitted, that read, "Flag any neuro-OBS cases running past 48 HRs. These are margin negatives under the current payer mix." He said that. That is a direct quote from the email, entered into evidence. I wrote it down. I did not say anything when the attorney read it aloud. I did not need to. I have been doing this for 22 years. The cases I choose to talk about publicly are the ones I believe need more people to know about them. Subscribe and tell me in the comments what is hitting you hardest so far. I read what people write. It matters to me. Callum's attorneys objected to the email chain. They argued chain of custody, argued that Reddy had no authorization to retain the document, argued that it was being offered to demonstrate intent in a case that was not pleaded as intentional tort. All reasonable objections. I overruled 2 of them and sustained 1. The intent argument I allowed them. The email was admitted not to prove a preformed plan against Margaret specifically, but to establish a pattern of administrative decision-making that prioritized revenue metrics over clinical timelines. That is a meaningful distinction legally, and it was the right call procedurally. But I want to be honest with you. That email did not leave my mind. Not from the moment I read it to the end of the trial. Callum testified in his own defense. He was composed. He answered questions as he had been prepared to answer them. When his attorney asked him about his decision-making process regarding Margaret's discharge, he said, "I relied on the available documentation and made a reasonable administrative judgment consistent with my responsibilities to the facility as a whole." He also said this, and I have thought about it many times since, when the plaintiff's attorney pressed him on whether he had reviewed Margaret's actual clinical chart before authorizing the discharge, not just the nursing notes. He paused. It was a 3-second pause, and then he said, "I trusted the process we had in place." I wrote it down. I did not say anything, but I have never forgotten those 7 words. There is something I need to tell you now that belongs to me, not to the case. When I was 31 years old, my father had a stroke. He was 58. He was in the hospital for 4 days, and he came home with a care plan, a prescription, and a follow-up appointment that my mother drove him to. He recovered well enough to walk his dog every morning for another 12 years. I thought about that when I was sitting across from Margaret. I thought about the 4 days. I thought about the difference between 4 days and 48 hours. I do not know if I would have been the same person I became if someone had sent my father home on Saturday morning. I never told anyone in that courtroom that. I am telling you now. By the time the attorneys made their closing arguments, I had made my decision. I want to be honest about that. I had made it the night after the 3rd day of testimony. I sat in my office at 9 p.m. with the case file and a cup of coffee that I did not drink, and I wrote down what I intended to do. I changed one number 3 times before I was satisfied with it. The morning of the ruling, Callum came in first. He sat down without looking at his attorneys. He was doing that thing with his eyes again fixed point on the table. His posture was still correct, but his hands, for the first time in the entire trial, were in his lap where I could not see them. Margaret came in 4 minutes later. She was with her daughter, a young woman in her 30s who helped her to her seat and then sat directly behind her, close enough to reach forward. Margaret set her cane against the table. She looked at me, just once, directly, for about 2 seconds. Then she looked at her hands in front of her on the table. The verdict was not what was going to matter most in that room. Both sides knew it. Civil liability had been established clearly enough in the evidence that there was no real suspense about the finding itself. The question was what I was going to do with it. I am telling you this story because I believe it needs to be told. Subscribe if you believe the same thing. That is all I am going to say about it. I found for the plaintiff, I read the finding plainly: negligent discharge of a patient in an active clinical recovery window, failure to observe physician-directed monitoring protocols, administrative override of attending physician authority without documented consultation. I read each line. I saw Callum's attorney write something on a notepad. I saw Margaret's daughter reach forward and put her hand on Margaret's shoulder. Then I moved to the penalties. I am ordering you, Derek Callum, to pay damages to the plaintiff, Margaret Osei, in the amount of $412,000. That figure covers her documented medical costs for the second event, her ongoing neurological therapy, and the calculated loss of income from her seamstress work across the projected period of impairment. I did not arrive at that number casually. I want to be clear about that. I am also suspending your ability to hold any administrative authority over patient care decisions at any licensed medical facility in this state for a period of 4 years. That means you may not sign a discharge form. You may not override a clinical recommendation. You may not hold a title that gives you administrative power over a patient's treatment timeline. 4 years, beginning today. I am also ordering you to complete 200 hours of direct patient care assistance at a publicly funded rehabilitation facility, not a private one, not one with a marketing department and a gift shop, a publicly funded one, under the supervision of licensed staff, not observation, direct assistance. You will do what the aides do. You will learn what that work is. There is one more thing. Within 90 days of today, you will submit a written, signed public statement, no fewer than 500 words, to the medical board of this state, to Northgate's board of directors, and to the state's hospital association. In that statement, you will describe, in your own words, what happened to Margaret Osei as a result of your decision. You will name her. You will describe the second event. You will describe what she lost. That statement will become part of your public professional record. You will read it aloud at the next scheduled open session of the Hospital Association's quarterly meeting. I am not asking you to perform remorse. I am asking you to say what happened out loud, in public, with your name on it. I also want to say this to you directly, Derek Callum, and I am saying it now to anyone watching this the same way I said it then. You made a decision about a woman you had never met and would never meet. You made it in the space of a line in an email. You called her a margin negative. You were looking at a revenue calendar when Dr. Nair was looking at a brain scan. Those two things were happening at the same time in the same building about the same human being, and they could not have been further apart from each other. I am not speaking to your family right now as an accusation. I am telling them the people we love are capable of decisions they cannot see clearly from the inside. That is not a comfort, and it is not an excuse. It is just something I have observed to be true. There is a thing that comes with authority over other people's most vulnerable moments. It does not matter if that authority is administrative, clinical, judicial. When someone is in a hospital bed because their brain had an event and their body is still in the middle of fighting for itself, they are not a census number, they are not a margin line, they are someone who was at a church function 3 days ago and was sitting next to the right person at the right time. That is the only reason they are still here at all. And what you do with that, what you choose to do with that, is the whole of what this case was about. I believe that a person who has genuinely reckoned with what they did does not look at the evidence table with a fixed point in the way you did, Derek. I believe reckoning looks different. I am not saying you are not capable of it. I am saying I have not seen it yet. That is what I needed to say. Thank you for staying with this. I mean that. I know this is a long story. I know it is not easy. Subscribe if you have not yet. You already know why you are still here. After I finished, I stayed on the bench while the room began to clear. Callum's attorneys gathered their materials quickly. He stood and straightened his jacket and walked toward the door without looking back. His lead attorney put a hand briefly on his arm as they walked. That was the only gesture between them. Margaret's daughter knelt down next to her mother's chair. I could not hear what they said. Margaret nodded once, slowly. Then she picked up her cane and she and her daughter walked out together, the daughter one step behind with her hand at her mother's back. The room took about 4 minutes to empty. When it was just the court staff, I stood up. The court reporter was saving her notes. She did not look up. There was a sound from the HVAC system in the ceiling. That is the thing I remember most about how that room felt when it was over. Just that sound and the absence of everything else. Callum's attorneys filed an appeal within 30 days. It was heard by the Appellate Division of the State Superior Court 7 months later. The appellate court upheld the finding and the penalties in full, with a one-paragraph addendum that characterized the discharge authorization as falling below the standard of care required of any party with administrative authority over clinical decisions. That ruling took about 14 minutes to read. I was not surprised, but I was relieved. On a Tuesday in early March, 14 months after the verdict, I received a letter from Margaret Osei's attorney. It was informational, not procedural. It told me that Margaret had, with the damages award, retained a full-time occupational therapist for 18 months. It told me she had taken on a part-time teaching role at a community textile arts program. And it told me that on the previous Saturday she had threaded a needle, standard thread. It had taken her 22 minutes and 3 attempts, but she had done it. That happened on a Saturday, the same day of the week she had been sent home. I have not answered the question that this case left me with. The question is this: at what point does an institution's need to function become a permission to treat the people inside it as a variable in a calculation? I do not have the answer. I have seen it happen in hospitals. I have seen it happen in schools. I have seen it happen in systems I am part of myself. I do not know where the line is between the legitimate pressure of keeping something running and the moment when keeping something running becomes a reason to stop seeing a person clearly. I do not know. But I know that the distance between those two things is where most of the harm happens. And I know that the people who cause the harm almost always believe they were on the right side of the line. If you have ever been in a hospital bed and felt yourself becoming a number, if you have ever felt the machinery of an institution moving around you with something other than you in mind, I saw that feeling on Margaret's face. I have seen it before, and I have never been able to look at it without feeling something I do not have the right word for. It is not pity. It is closer to recognition. You deserved better than that moment. You deserve someone in that building whose first question was about you, not about the room you were taking up. I am sorry that the system did not protect you before you needed a courtroom to do it. And if you hold authority over other people's vulnerabilities, if you have a title that puts you between a person and the care they need, I want to ask you one thing, not as a lecture, as a question I wanted to ask in that courtroom and could not. When you made the last decision that affected someone at their lowest point, did you know their name? Not their patient ID, not their case number, their name. If the answer is no, that is the place to start. That is the only thing I can offer you. Start there, not for them, for what you are still capable of becoming. There are other cases I want to talk about. This is not the only one that stayed with me. Subscribe and you will hear them when I am ready to tell them. I still think about that administrative log entry. 3 lines. The timestamp 9:17 a.m. The phrase margin negative in a 6-page email that a billing coordinator printed and carried out of a building in her bag because she knew it mattered. I think about what it took for Anisha Reddy to walk into that courthouse. I think about Gloria Acheampong, who knew what was happening before Margaret had finished her sentence and did not wait. I think about a woman in a navy dress setting a cane against a table with careful hands. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. The comments are where the people who care about the same things find each other. I read them. I want to know what you are carrying when you finish watching something like this.